Having your residence application declined is devastating. It's hard to think straight. How do you fight this? Hi, I'm Simon Laurent. I'm the principal of Laurent Law Barristers and Solicitors. We're a specialist New Zealand immigration law firm practicing on the outskirts of Auckland. We deal with all sorts of immigration matters, but in particular, we handle the hard cases that others simply don't know what to do with. This includes some of our professional colleagues, and we receive referrals from other lawyers and licensed immigration advisors where the cases are just outside their field of experience. So today I'm going to talk about how to appeal against a declined residence application. The key with these was explained to us some years ago by a senior member of the Immigration and Protection Tribunal, which is the body that considers such appeals. And their statement to us was, you need to put forward the hook line of the case, the key feature, something that makes it stand out, and everything else can depend upon that hook in order to tell a compelling story that will bring about a successful outcome. Our job as professional advisors is to identify that hook and to work it up into that strong story, to tell your story better than you would know to tell yourself. Now, there are two main ways in which residence decisions can be appealed against. The first one is that immigration has made the wrong decision, and the second is that there are special circumstances that justify an exception to the usual rules. Coming back to the first one, that is, that the decision was made incorrectly, this doesn't just mean that immigration has made a decision that you don't like. They must have done it in the wrong way. And that can come about in a couple of different ways. For example, that they have misinterpreted the wording of the residence instructions that they're required to apply. That can require a bit of skill in order to identify that they have done this. Another way is that they have followed the wrong process in making the decision, and this usually, or very often, can mean that they have not given people the right to comment upon a concern that they had about the case before the decision was made, so that they have effectively denied the applicant what we call the right to be heard. Another way that the case can be turned around that is similar to this but slightly different is that new information arises during the course of the appeal which justifies the case being sent back for reconsideration. For example, someone has applied for residence based on a job that they have, and during the appeal they get a new job, a good one. In that case, the Immigration and Protection Tribunal can direct immigration to go back and look at the case again based on that new material. This can be especially important right now because at present, at the time I'm speaking, the category of skilled migrant residents has been effectively closed down owing to restrictions upon the applications for visas during the COVID-19 response. Therefore, you want to find a way to keep your residence case alive if you possibly can, and that's a very good argument in favour of filing an appeal even if you're not quite sure. Now, getting a decision made based on an incorrect application of immigration instructions doesn't necessarily get you residence outright. In fact, it very seldom does. What it does do is get the case back in front of immigration once again to have another look, and usually with some pretty specific directions from the IPT as to the way that immigration is meant to do it, because they got it wrong, and therefore immigration needs to be directed as to the way to get it right. Now let's look at the second main heading upon which an appeal can be founded, and that is that there are special circumstances which justify making an exception to the usual rules. Now, what special means is a pretty open question. Every person's case is different. It's hard to make too many hard and fast rules about what is special and what is not. It's a bit like you know it when you see it. Now, it could be a combination of factors which, coming together, make the case special, except that if you looked at them separately, you wouldn't think that they were so special. So the case in the round can be built up in order to demonstrate that there is really something that needs to be addressed. There's a wrongness about the decline that needs to be righted. Now, I can give you an example from Laurent Law's own experience, and we've done dozens of such cases. And this relates to a partnership residence application. The case was declined because it was meant to be based on marriage. Unfortunately, one of the partners was still married when they to a previous partner when they married the present partner who was applying for residence. So that effectively it was a bigamous relationship. On that basis, it was declined. However, on appeal, the Immigration and Protection Tribunal decided that this was a special case because, mainly, the couple had a child who was a couple of years old. It was generally accepted that the relationship was genuine and had been going on for several years. But the fact that the child was present really took this outside the realms of the ordinary and demanded an outcome that would protect the child's interests, which are considered to be a primary consideration. An important point to bear in mind with a residence appeal is that it must be filed within 42 days, that is 6 weeks, of the applicant receiving the decision. Now, as most decisions are emailed to applicants nowadays, that means it's 42 days from the date of the letter in which the decision is contained. An important point, because if you don't file in time, you lose that chance to appeal forever. Why would you need legal assistance to deal with one of these cases? Well, as I've already said, a firm like ours has done a large number of appeals of this sort. Secondly, we have some experience in choosing the right arguments to put forward. And sometimes those arguments are not obvious, especially when it comes down to interpreting whether the residence instructions have been applied correctly. We can pick out the technical breaches and make the most of them in order to get a reassessment made. We are also experienced in finding what the special circumstances are that a family, an applicant, could represent, which could enable an exception to be made. This is the work that we do. This is the work that we do all the time. And it is a reason why you should consider coming to us if you or someone that you know has had their residence declined and the clock is ticking. If you wish to reach out and find out how we can help, you can call our office. You can email me at slaurent@laurentlaw.co.nz, or you can visit our website on www.laurentlaw.co.nz. Thank you for your attention, and all the best.